we will answer your questions at the end. Naveen, can you announce where audience should post their questions?
Yes. We will answer. Thank you, guys. So please, everyone, once the webinar is done, we will open for Q&A session. Please post your questions in the Q&A session only, so that it will be easy for us and as for the speaker to answer those questions rather than jumping around with the chat and the Q&A. So I request everyone to please post your questions in the Q&A. Thank you. So Satish, it's 3:05. Should we start? So yeah, I will request our Itserve Vakil Saab, Satish Nagila, to take over. We call him Itserve Vakil Saab. So please take over, Satish. It's 3:05. So we almost have 200 people already waiting.
Yeah, let them join. Let's start because we have odd stop at 1 hour. We are going to close this in the 4 p.m. CST. Thank you, everyone. Good evening. My name is Satish Nagila. I'm the PAC director this year. Thanks, Naveen, for hosting as a immigration chair. First of all, Banu, thank you so much for joining and trying to give us the good updates and the current affairs, especially the H1b cap season is coming. Before we start our discussion and presentation on the situation, just I would like to give a quick update to our members about the upcoming litigation. Itserve is committed to support and help the community business for our organization members. So we are considering the potential litigation on the h1b modernization. Most of you guys might have already seen that what is required for us to successfully win the lawsuit. We need the RFEs. If you have any short-term approvals, if you have any of the RFEs that they're asking for the bona fide offer, third-party placement, and specialty occupation, we need those kind of RFEs. And especially the FDNS officers' audits, if they are asking too many of questions and too much of data within the short period of time, those are all the potential consideration scenarios for our litigation to be a successful one. This is very essential for us, for survival of our business. Without your support, we cannot success this litigation. So I sincerely request you all, send these data to pac@itserve.org, pac@itserve.org. Then, our litigation attorney, Jonathan, with his staff, Justin, they will pick it up and they will move forward with our litigation. Naveen, do you see Anju or Shiva? Maybe they wanted to give the opening comments meanwhile. So, dear members, this is very essential and need half an hour. We don't have much time to wait and see this. But, this is my sincere request. Please do support for our litigation efforts. Being said that, thank you. Banu, just, so much is going on in our immigration world, especially the H1b modernization rule, which they released in the December and got effected from the 17th of January 2025. This is especially that we see the employment and employer, right, the association, they are talking more about it. And I would like to, share your thoughts and your ideas and your knowledge about all this H1B modernization and new rules that is going to affect our business. That is irrelevant to the, general our business operations. Once you give your thing, then after that I'll open up my questions first. Then we'll go to the audience questions. Banu, it's all yours.
Thank you, Satish. Thank you for giving this opportunity for me to be part of today's webinar. And before I want to start the topic, what you wanted me to discuss and everything, I just want to tell everyone what Satish just said for the members. It's very, very important to provide that information so that Itserve can actually do a successful litigation on this h1b modernization rule, as it is very, very important for us to show that how ultra-virus USAS is with this h1b modernization rule, and how in implementation it can be actually misinterpreted or abused by the agencies and everything. So really, we really encourage all of you to provide such information to the Itserve so that they can do a successful litigation on these matters. And first thing, most important thing, the important changes what we worried about.
Banu, with your permission, if you don't mind, sorry to interrupt. One thing just I wanted to let our members know that whatever the information that you're providing is proprietary, and we're not going to share that, and these are not going to be a plaintiffs. Okay, this is not going to be a plaintiffs. If at all we need to use a plaintiffs, we will let you know, and without your permission, we're not going to do that. And participating in the litigation, nothing harm in terms of, in fact, that's going to be favorable for you guys. It's not like, any other country where the agency or officers will come behind you. This is a more supportive thing only. Just I wanted to share my thoughts. Ban, please continue, sir.
Yeah, thank you. As per our topic for the CAP, filings of and dealing with h1b modernization rule, most important thing we all have to understand is that now the CAP registration fee has been increased from this year to $215 per beneficiary. And the requirements for the CAP registrations have not changed anything from last year. It is still beneficiary-centric selection process, and the registrations has to be submitted in the month of March, most likely. This year, I think it will be from March 3rd to March 17th, because March 1st and March 2nd being on Saturday and Sunday. So it may start on March 3rd and may end on March 17th this year for the h1b lottery registration. And the USA's fee is $215 per beneficiary. Please remember that it's no longer $10, it's $215 per beneficiary. And second, another thing is, once the case gets selected in the lottery, we all know that we have a time to file these h1b petitions from April 1 to June 30th of 2025. The most important thing, the changes which h1b modernization rule made is that prior to that, you just have to establish that you are a bona fide employer and you have a requirement of an individual in a specialty occupation based upon the nature of your business. That is what is the requirement was before this h1b modernization rule. Because of the kudos to Itserve, because of the litigation and the cases they filed and the results they've gotten, we were able to establish only that and able to get h1b approvals for the past 4 years, from 2020 onwards until 2025 fiscal year. But now these things are going to change. And with the h1b modernization rule, they're going backwards now and trying to implement most of the requirements that were part of the Neufeld memo, which was issued in 2010 by the USCIS. Now they codified it through regulations, and they were requiring that the employer must have a bona fide job offer in the specialty occupation at the time of filing, showing that the bona fide job offer exists at the start date of the requested validity period. And the USCIS did not define what does it mean by bona fide in its regulations or anything like that. And I strongly believe that they just used this as a complementary or a substitute to the term non-speculative in nature. Okay? And because of this particular issue and other changes made in the regulations, sometimes we can expect that they may approve H1Bs for short-term durations, and that is where we have a problem here. If that happens, then automatically we have to understand that you may get an approval for 3 months, 4 months, 6 months, we do not know. So that is one possibility which we have to look into with this CAP filings. We have to establish that you have a bona fide job offer at this requested start date of the validity of the H1B petition. And that has been very, very important requirement we have to worry about with the H1B CAP filings, because H1B CAP filings, requested start date will be from October 1, but you will be filing these cases anytime between April 1 to June 30th. So you need to have to establish that you have a job offer, bona fide job offer available for you from October 1, 2025, even if you're filing the case in June 30th, 2025. So, and also they're saying that USCIS, to show for the purpose of bona fide job offer, they can demand contracts, work orders, and other similar evidence between all parties in a contractual relationship showing the bona fide relationship or bona fide nature of the beneficiary's position. That is what the regulations say. And these are the things which we have to keep it in mind in preparing H1b petitions during the H1b cap seasons. Of course, there are certain strategies which we can discuss on a private basis, one-on-one with our clients. But in general, these are the requirements we have to meet when filing H1b petitions. And obviously, there was a change on how to determine a specialty occupation also to the criteria that has been stated in the regulations, where they did not make much difference, but a little bit difference into the definition or the criteria requirements of the specialty occupation requirements, where they say that at least we have to meet one of the four of the criteria, but I think the commentary section of the regulations clearly says that USCIS intends for you to establish all four criteria to show that position qualifies as a specialty occupation. So, and those are very, very important things which we have to keep it in mind. And the third thing is, it's very, very important for all of you to understand it is not as bad as you think, especially when you say that the regulations require that you have to show what are the requirements of the third-party company. That means the end client, for the purpose of showing whether the position qualifies as a specialty occupation or not. But it is only required when the beneficiary fills the position in a third-party organization and becomes a part of the third party's organizational hierarchy in the particular hierarchy, rather than just providing services to the third party. So it's our burden to prove that our employee is not becoming a part of the organizational hierarchy of the third-party company. If you can establish that, then we can show the requirements of our company as a specialty occupation. That is the language giving a small benefit over there in the regulations. Probably there's a little bit of wiggle room for us to work on that, and I'm very happy to discuss in detail on this particular issue on how to tackle and handle this issue. Because of the lack of the time, I'm not able to spend too much time on this event right now, because we have to cover so many issues for the H1b cap filings and everything. And also with the H1b cap filings, we have to understand to deal with the site visits also. Now, under the H1b moderation rule, site visits have become mandatory right now. So, and they said that they can do the site visit verifications at the employer location or the beneficiary location or the independent locations or even at the third-party locations. And also they can do the inquiry with the third-party companies also, for which actually beneficiary for provide services. And if the third-party companies do not cooperate on providing information, that can be used against for the refusal or denial of an H1b petition. That is, I think, it's a little bit overbroad because we can't control the actions of the third-party company, and the third-party companies are not the parties to this H1b petition. I think they're coming back for that particular requirement about the definition, which they said that if the beneficiary is filling the position in the organization, third-party organization, on their organizational hierarchy, as part of that hierarchy, then these issues can come up for us, and that is where we have to differentiate. The reason why I'm saying this is in the past to show that beneficiary is working for the third-party client, when we do not have an end-client agreement or a work order or a client letter, we used to show the organizational charts to show that where the actually beneficiary fits in the particular organization, what is he doing and everything. And it's very important to show that the beneficiary is not actually filling any hierarchical position in the organization. He's just being an independent contractor providing services on OPR. Then probably we can avoid this kind of erroneous denials by the USCIS. So that's why it's very, very important. I'm stretching this point once or twice in this requirements for the H1b cap filing, Satish.
Yeah, Banu. So, with this modernization, let's start the process of everything. Does um, posting advertisement requirements, is there any change in that process, or is it as is old?
It is the same as any other regulations, because the advertisement requirements comes from the Department of Labor requirements, which is the labor condition application requirements. If you are an H1b dependent employer and if the employee does not qualify for the H1b dependent exemption, then you're required to do the recruitment to find a qualified US workers, and also you have to do additional attestations to the Department of Labor while submitting your labor condition application that you are not replacing any US worker 90 days prior to the filing of a H1B petition to this H1B worker, or 90 days after the filing of the H1B worker also. So displacing US worker is a very, very important component for if you're a dependent employer. But if the employee qualifies as a dependent exempt employee, that means if the employee is getting paid at least $60,000 per year, or if the employee has at least a master's degree or its equivalent in the specific specialty in which you will be employed, then he can be considered exempt. Then we do not have to do that additional attestations or do the additional recruitment or advertisements to find a qualified US worker. So those are
exactly
changed yet.
Nice. So, especially in our consulting business, hiring practice is very essential for us to maintain, to process that. So, making sure our members are aware of that, and that is one thing. And when it comes to the registration, I am sure portal is not ready yet, the new version. But do you expect any requirement changes other than the registration fee from $10 to $250? Anything else that you see?
No, I don't see any changes, because the changes, whatever they want to implement, it has to be done through the regulations. If it is not done by the regulations, they cannot implement any changes. And the regulations still require the minimal requirements or minimal information from the beneficiary and from the petitioner who's submitting the registration by paying the USS fee $215. And we all know that multiple registration is still prohibited from the entity or its related entities or affiliated entities. So we still can't do the multiple registrations. And so it is what it is. And the chance of getting selected in the lottery will be substantially higher this year because of the new system which they implemented, which is the beneficiary-centric selection process.
Yeah, that is very true, but basically these days, especially last year, the systematic RFs, the way we have seen is USCIS drafted a topology, whatever the affiliated, associated companies, even your relatives, your siblings, your close relatives, those companies also, they listed it. Mm-hmm. So in such a way, if you see, for example, there is a K-Force and me, if one guy is applied with the K-Force and my company also, we have a transaction, the financial transaction and agreement. Is that also see that affiliated, or is it like a pure business relation? What do you think of those kind of relations?
That's a pure business relation. And see, there are a lot of factors into a consideration when they're considering if any company is affiliated or related. They're looking into their social relationships also, and they're looking into how many duplicate registrations happened in between company A and company B. That is also they're looking into. Having one registration or two registration can be coincidental sometimes in a situation like what you are saying, K-Force and your company. And because K-Force is a vendor for multiple companies, and you may be working as their vendor or as a sub-vendor for them to provide services to the third-party companies, which are the ultimate end clients. So that's a pure business relationship. I never had an issue with that, and US has never revoked any H1B petition for multiple registrations based on that.
Okay, nice. So after the registration is done, of course, the selection process goes, then immediately we need to file an LCA. Mm-hmm. Do you see the modernization rule impacting any way on the DOL LCA side too, or just it's on the, the I-129?
It's purely H1B moderation rule. The impact will be on how USCIS is going to interpret and adjudicate the H1B petitions. Not the Department of Labor. Okay? And that is very important thing, because you still have the Department of Labor regulations that governs how the Department of Labor is going to adjudicate the working conditions of the foreign workers in your entity. Okay, that means whether you're complying with the occupation stated in the LCA or not, whether you're paying the wages that are required to pay for the h1b workers what is stated in LCA, or these wages are incommensurate with the other US workers in your company in the same or similar positions or not. Those are the things will be looked into the Department of Labor. Even USCIS can also look into that. That's the reason why they're coming in to see whether you're complying with h1b regulations or not. But Department of Labor will not anyway involve in seeing these changes with the h1b moderation rule, because predominantly the h1b moderation rule is actually applicable to show whether somebody is eligible to get an h1b visa, h1b status in this country or not, whether they qualify for h1b petition or h1b status in this country, so that they can be employed in h1b status and work in this country. That is what predominantly h1b moderation rule is dealing with.
Okay. Okay, nice. Yeah, nothing to do with it. So, what are the actual requirements to file a H1B petition as per the new H1B modernization rule?
That's a great question, and the requirements is that the employer should be able to establish that the individual is a person or a firm or association or a corporate or an entity that is actually is in the United States and available to the service in the United States as a taxpayer identification number also for them. And this employer has a requirement to hire an individual in a specific specialty for which they intend to hire an individual in a specific specialty position that requires at a minimum bachelor's degree or its equivalent. And usually the criteria, how do you determine that is, as I said, first thing which they will look into is whether the position normally requires a bachelor or higher degree in the field of endeavor in which the employer will be employed. And two, they also look into that is usually the companies which are employing in a parallel position generally requires parallel position of which you are intending to file an H1B petition usually requires a bachelor's degree or its equivalent in a specific specialty that is directly related to the field of endeavor in which employee will be employed in your company. And third important criteria which you can look into is that the employers or third party companies for which generally the beneficiary will be providing services, and will be providing services normally requires a bachelor's degree or its equivalent in the specific specialty, or the job duties are so complex or specialized in nature, such a skill can only be attained through a bachelor's degree or its equivalent. If the employer can establish this criteria, these requirements in filing an H1B petition at the time of filing of an H1B petition, then the H1B petition will be approved. Main thing is that they have to show that they have a bona fide job offer requirement in the specific specialty in which they intend to employ the employee.
Okay. Especially in the Form 1, I-129 that we see in the section, the proposed employment and employer, that is where they're hitting seriously. Is this a third-party location, right? That is a serious question they're asking. They're asking twice. I'm not sure why. It's the typographer. Are they trying to find out something? In conjunction with the same question, my point is basically we are trying to file the petition in the month of, from April to June, something like that time frame. But the H1B approval is going to be from the October 1st, right? Mm-hmm. And we don't know how the client is going to be awarding the position to us. Sometimes there may be a employee to vendor, then client, then maybe or there may be a direct association, right? There is a lot of other combinations. We are not certain. We are not sure at that point of time to answer that question. So how do we deal with that situation and what are the consequences? Can you go a little bit more in detail? That is specifically they are targeting the employee-employer association, the relationship, and I think they are trying to redefine the definition of the employer. Can you elaborate as much as you can, Banu?
You're absolutely right, Satish. That is what they're trying to do. They redefine the definition of an employer and the employer-employee relationship. Especially, it is going to impact when the employee is going to work at the third-party client sites, right? Or if the employee is going to provide services to the third-party companies rather than the company which is actually hiring them directly. Okay, and for that reason, in the form I-129, they're asking about the client information. If he's going to work at the third-party client side, you're going to provide the client name and the address where the beneficiary is going to work. But there are circumstances where beneficiary, even if they're going to provide service to a third-party company, they may be providing services remotely from their home rather than from the third-party company. And at that time, you have to mention in the form beneficiary's residence at the worksite location and the beneficiary address, residence home address will be provided in the LCA as well as in I-129 also. And see, that in order for them, they're expecting you to provide the documents establishing the relation between all the entities that are involved in between. For instance, as you said, if your business relationship for your employee services is in EC model or EVC model or EVPC model, that means employer-client model or employer-vendor-client model or employer-vendor-vendor-client model, whichever way it is, it's as an employer, they're telling you that it's your responsibility to show that you have a contractual relationship among all these entities involved in between for the beneficiary services in a specific specialty in which you intend to employ. Okay? And that is what they're looking into. That's why we have to show the client agreements, purchase orders, and all these things will come into existence. And of course, sometimes we may not have that. We may not have the end-client agreement for us because, especially when it's an EVC model or EVPC model, we may not have an end-client agreement with our company. But that is actually one way it's a good thing for us, one way it's a bad thing for us. One way it's a good thing for us because we can clearly show that employee is not becoming the part of the organizational hierarchy of the third-party company. He's just providing services to them as an independent contractor, as our employee. So one way it becomes easy for us, and one way we have to establish the relationship also. It's really very muddling situation if it comes to reality, and see how USCIS will adjudicate these cases, depending upon how we present our arguments while we are preparing the cases. And it's very important to prepare these cases in detail, explaining what the regulations are and how those regulations are applicable in this particular situation. So that is very, very important. And if you do not have this agreement, that's the reason why we bring the client letters over there. If the clients or vendors give us a letter exactly what the position is all about and what the requirements of the position and what kind of relationship they have with our company, and I think that will be sufficient in lieu of these agreements and the contracts or purchase orders, whatever we need to establish.
Do we need to submit the master service agreement, the engagement contract with the client at the time of applying the petition, you think this time, or it is not required?
It is. They're saying that we have to submit some kind of a documentation, especially if the employee works at the third-party client side. We have to provide some kind of a document that establishes a relation with the third-party client for the beneficiary services. So it could be MSA, it could be SOW, it could be purchase order, it could be work order, or it could be just a client letter also.
So being said that, the question in the form I-129, employment and the employer proposed, they are asking, is it a third-party location? They are not asking, is it third-party position? Is there any distinguished difference that the location could be, the employee could sit in my office, or if it is a remote, he'll be sitting in their office. But that point of time, do we need to reveal, is the work going to work for our in-house project, or to define certain end client project, or can you go over? I think that is kind of a tricky thing. Can you try to elaborate that?
Definitely, Satish. That's a very good question. I'm very happy to provide the clarification here. See, the form amendment is where the employee is providing services to third-party client site location, right? It's not asking whether he's providing services to third party or not. It's asking about whether he's going to provide services to third party client location or not. Because if he works at the third party client location, we have to state that in LCA as well, with the Department of Labor, to provide proper prevailing wages are offered wages as per the prevailing wages in that particular location. And for that, you will answer yes if he's working at the third-party client location. If he's not providing services at third-party client location, if he's providing services remotely from your office, then you will say no to it, because LCA only reflects your office as a work location over there. It need not be in-house project. It can be even third-party services project where they will be providing services from your office, and still you can do that. But that is something which you have to establish whether the requirement is your internal or external.
Okay.
And
Yeah.
That's what it is. Those fields are not mandatory. That's why it's not mandatory that you have to provide a client information in the form I-129, because you can employ a person who's not required to provide services on the third-party client side. For instance, let's assume employer is a law firm like us, right? And we are hiring a lawyer on H1b visa. The individual will be working in our office location. He's not working at the third-party client location as an attorney. So we don't have to provide any information over there. We'll say just no, and then we leave it. So that's how it is. But if the employee is going, if my attorney is going to work from his home, then we will say that yes, and then we will say beneficiary's residence, and we will provide the location because it's a third-party location. Beneficiary residence is a third-party location if it comes to as a matter of an employer.
Okay, that's good.
So these are the things which you have to keep it in mind.
Right. So, on the LCA, let me think of one more thing. Actually, most of the consulting firms right now, they are struggling with the wages, especially when we try to do the software developer, software engineer, right? The wages, at least the level 2, it's very high in the prominent places. So, the alternative wage prospect, if we go on that, what is the possibility of not denying and getting their approval and lowering the wage in the higher metroplex like DFW or New York or California? What is your thought on that?
We always use alternative wage surveys for the H1b petitions, especially in a metropolitans like San Francisco Bay Area or Seattle, Washington, Seattle area, and all this is where predominantly OES wage survey has very high prevailing wages over there.
Absolutely, that's a very good point.
Yeah, we always use alternative wage surveys in those particular survey areas and everything. The reason is at least there will be a 10,000 to even if there's a difference of $10,000 per year, that's a huge money when it comes to 10-15 employees in the company.
Exactly.
And alternative wage surveys has to be reputable wage surveys also. That means they need to have a proper data. That means they need to have at least 30 employers in that particular location, which the data they have collected from that location. These are the parameters which USCIS and Department of Labor look into to certify labor condition application as well as the H1b petition. Okay, they just can't say this is our data, we did this. No, they have to show the parameters, how the data has been collected and what are the size of the companies they have collected and how many employees were there in those companies and what data they have utilized and what are the comparable studies they have studied. All that information has to be provided in the alternative wage surveys. And accordingly, they determine what the wages are for a particular position, depending upon which level also in that. Senior level, entry level, and all these things. And based upon that, they can use the alternative wage surveys. Of course, we have seen USS issuing recently some RFEs on them, but we did not get any denials. We always respond to those RFEs with those wage surveys, data, information, everything, and we get the approvals. They cannot deny that it should be based upon that. So I would strongly recommend to use the alternative wage surveys under these circumstances. And the best alternative wage survey in the market available is the Watson-Biat alternative wage survey. It's expensive, but that is the best alternative wage survey available right now in the market. We don't use other ones. We use Watson-Biat because we had 100% success rate with that particular alternative wage survey.
Absolutely, Banu. That's a great point because, I know the situation, even I use that, I recommend that, but I want our members to know that from a reputed attorney like you so that they'll, prevail this advantage of using that. Yeah. Now, being said that, these H1B, these filings and whatnot, these things are changing, modernization tool is in effect right now. After filing the petition, what do you think the post-filing situation is going to be in terms of RFEs, in terms of, once they get approved, these days we are hearing that, at the POE, they're, sending back asking that, okay, it's been stamped 6 months ago, your job is, 3 months ago, why, these kind of situations. What do you think the overall picture, and what's the precaution awareness that you wanted to bring to our members?
Very good. I mean, I will talk about this particular cap season.
So,
Yeah. Rather than talking generally what's going to happen after post-filing of an h1b petition, because of the lack of time we have, and the purpose of the call is just for the cap listing. The main thing is with the cap filings, once you do the h1b filing in the cap, you can expect having a site visit anytime at the time of adjudicating of the petition, or even after the adjudication of the petition. The new h1b moderation rule does not provide any time limitation on the USCIS on its authority to conduct the site visit on this matter. Okay, and these site visits can happen either at the company location or the beneficiary location, even at the third-party location if the third-party location is stated in the LCA or in the h1b petition. Actually, we have to state in the both. We cannot say or; it has to be both. Okay, and so that is one thing which you have to expect and understand that can happen. Another thing is, you can expect to get an RFEs on a specialty occupation, especially if the job duties are not clear, and if the education is not directly related to the specific specialty in which you are intending to employ. Now the regulations clearly state that general degree requirement in any position for any position is no longer acceptable. The specific specialty must be directly related to the field of endeavor in which you intend to employ. The directly related is a very strong which they're using into it. That means we have to show the relation between the education and the position for which you are working on. So there is a possibility of increase of specialty occupation RFEs in the coming cap season. We have to be ready for that. And we have to be ready about demanding client letters, client agreements, purchase orders, and all these things also. And also they may say that although this is non-speculative employment, you do not have to provide day-to-day assignment requirements for the entire duration of the h1b petition. But the regulations do state that they can issue a short-term approval depending upon how much duration we can establish for a job availability, and they will issue a small brief explanation attached to that approval why they approved it for short term only. And so most likely the duration of the requirement, even though they don't require you to provide an itinerary, probably they may stretch you in these RFEs asking you to provide a purchase order SOW for the entire duration of an h1b petition. That is one litigatable issue here for the Itserve. It's very, very important to see the contents of these RFEs. That's why all of you should provide these RFEs when you're receiving them, so that Itserve can actually make a very strong case against this h1b moderation rule.
Thank you, Banu, for reminding that one more time to our audience. Appreciate it. Since we have 18 more minutes for this meeting, I'll ask one last question before we let the audience, questions come into your way. How are the OPT students impact with this h1b modernization rule? Tons of OPT students are out there who are graduated. They are, looking forward to getting h1b. Look like that's going to be a hammer on them. So can you give some information, some thoughts on that?
That's a very good question, Satish. And I was very eager to talk about this also. Because
Thank you,
many of my clients do employ STEM OPT students and OPT students, and they try to sponsor H1Bs for them. So I really want to talk about this. I'm glad you brought this question here. See, the H1B moderation rule has some positive changes for the F1 students, and also at the same time some restrictive changes also for F1 students. The restrictive changes is now for STEM OPT students, now they're demanding to show that they're eligible for STEM OPT, especially if they work in the third-party client side, to provide the agreements, purchase orders, and other things, just like how for the F1, for the H1B petitions are required under the H1B moderation rule. But I don't think anywhere in the regulations I didn't see the language for such requirement for the F1 students in the H1B moderation rule, but we are seeing this kind of an RFs coming for the STEM OPT students. I think that is going to increase a lot with this H1B moderation rule. I think that is one thing which it's a potential litigation issue for F1 students to fight on with the USCIS. That is one thing which they have to keep it in mind. And second thing is, it's very important for them to understand. For them, the one good thing about them is, as of today, the cap gap is extended, especially if their OPT or STEM OPT is expired after the filing of an H1b petition for them. In 2008, they extended the cap gap for them, allowing them to have a temporary work authorization until the commencement of the particular fiscal year for which you are seeking an H1b petition. That is till October 1 of the particular fiscal year. But now, they have extended that to the April 1 of the fiscal year for which you are seeking an H1b petition. So that is a very good news for the F1 students, especially who are in cap gap, whose OPT or STEM OPT is expiring, and they don't have any other extension to be done. They are authorized to work until April 1 of the fiscal year for which you sought an H1b petition, while that H1b petition is pending for adjudication. Because we know that we are taking longer durations getting H1b approvals, more than 6 months these days, especially with the cap petitions. So that is a good thing with the F1 students. And it's very, very important that F1 students make sure that the employers, when they are employing F1 students, do not give, I would say, make sure that their job as an F1 STEM student description is different from the job descriptions which you'll be employing them on H1b petition. You do not have to employ in the same position what they're working, employ in a different position while you're filing an H1b petition. The reason for that is if you're paying very lower wages for them while they're in F1 STEM OPT because they're not covered by the WHD but by FLSA requirements where they're required to pay minimum wages to them. But however, under the discriminatory laws, that can be considered as a discriminatory practice because based upon their immigration status, you're paying them less than the other immigration or other workers in your company for the same position. So that can cause a problem for you. That can cause a lot of issues for you. So make sure that the job descriptions or the jobs for which you hire in your company, STEM OPT students, should be really, really basic entry level or below that entry level as a trainee. That is very, very important to specify that in the job description, especially when you're filling form I-983, and complying with I-983s is very, very important for F1 students. And also, employers also, they have to comply with the I-983s, and also they have to comply with the employee verification every 6 months, every year, whatever is required. Those things also has to be complied by the employer, because if they don't, the Department of Labor and the US and the ICE can come behind the employer for that also.
Great, Banu. That's really good news for the students, especially on the cap gap. I have seen so many students got struggled with that in the past, but that's a good thing. Now, I would like to request and remind one more time to our members about the upcoming litigation that Seriously Leadership and Itserve organization is considering on the employee-employer relationship, job, third-party position, and FD site visits and the redefinition of the employer. Without your support, we cannot make it stronger, our petition. So please do send the RFPs that are associated with this stuff. If they're asking a third-party position, job itinerary, short-term approval, FDINS, asking too many questions in the short period of time, whatnot, these kind of RFPs information, please share with the pack@itserve.org. Your help is, very much needed on the timely fashion. Being said that, I would ask Kiran to take over the audience questions, and Banu is here. We have a few more minutes to cover. Thank you, Kiran. You're on mute, Kiran.
Yeah. Can you hear me now?
Yep.
Hi, Banu. Thank you, Satish. And we have a couple of questions. Maybe Banu would have answered or covered before, but I will still read it either way. So,
first of all, Kiran, 1 second. Actually, dear members, please channel your questions through either Q&A or chat one. It will be difficult for the Kiran to take care. Okay, go for it. Which one you prefer, Kiran? Tell them and proceed.
What was that? Q&A.
Q&A or chat, where they want.
Q&A is better.
Okay.
Q&A is better. Chat is confusing.
Proceed.
Yeah. So please elaborate demand contracts between who?
the contracts between the employer and the vendor and the client, or employer and the client. That is what they will look into to see, especially when the employee works at the third-party client side, whether you have a bona fide requirement for the beneficiary services in the specialty occupation or not. And here,
it's basically a full chain, right, Banu? It's a full chain from C to E, right?
Yes, it's a full chain. That's what they look into. And also it's very, very important when we are talking about the third-party requirements. I said that in the beginning also, but I want to say again one more time also. The USCIS will try to pin to you saying that only the way you can establish specialty occupation in your company or for the position qualifies as specialty occupation only based upon the requirements of the end client rather than your company, because the beneficiary is providing services at the third-party client location or for a third-party company, But as I said, we have to show that requirement, that third-party requirements, for the purpose of showing the position qualifies specialty occupation only as per the regulatory language in the h1b moderation rule is that if the beneficiary services have been contracted to fill a position in a third-party organization and becomes part of the third-party organizational hierarchy by filling a position in that hierarchy. That is very, very important. Just providing services to third party, it don't require to show the requirements of the third party company for the purpose of showing it as a specialty occupation. Only requirement is that if the beneficiary is going to fill a position that is part of the organizational hierarchy of the third party company by placing this beneficiary in the third party company, then we have to show the requirements of the third party company for the purpose of showing specialty occupation. That means just an agreement and purchase order also may not be enough. We have to show the requirements of the position also from the third party company. That actually complicates the issue for us when it comes to the h1b petition, because the requirements sometimes third party, the client companies may not state properly what are the education requirements and what are the experience requirements are for these positions also. And sometimes when we file, it also becomes an issue for us with the level 1 wages and level 2 wages also, or level 3 wages also. For instance, most of the times we file a position in level 2, level 1 because the wages are so high for the h1b workers compared with market standards and everything. But if it's a level 1, level 2, the position should not require a bachelor's degree and its equivalent and an experience not more than 2 years. If it requires anything more than 2 years, then it will actually exceed the SVP requirements, that means specific vocational preparation requirements for that position. So you may pay up, and you may require to pay level 3 and level 4 as per the Department of Labor and as well as the USCIS also. So if the client says that position requires 5 years of experience or 10 years of experience with a bachelor's degree, and if you're paying level 2, that can become an issue and that can eventually result in the denial of the h1b petition also. So it's very important for us to differentiate that the employee is only providing services to the third party company, but is not a part of the organizational hierarchy of the third party company. It's very, very important for us to document this. This is a very crucial point which will save us by not requiring us to show the requirements, what the third party company's requirements are for the position for which beneficiary will be employed in your company.
Banu, we have too many questions, short time to cover many. Can we go to the specific to that rather than, they can consult you for the elaboration and how to, work it out. That helps majority of our members. Kiran.
Perfect, yeah. Do we need to have a job offer, bona fide job offer at the time of registration itself?
No, not at the time of registration. The regulations requires us at the time of filing, you need to have a job offer is available at the requested start date of the h1b petition.
I see. Can we file new h1b registration for candidates who are in India without a client job or without a job?
You can always submit the registrations, as I said.
Registration, yeah. That's a long one. So I've completed my PhD in management with a specialization in marketing. And I would like to know if I'm eligible to apply for EB1 visa. This is different question totally.
You can consult us privately. Very happy.
Okay, sure. How are in-house applications scrutinized? Anything to be careful other than we show we have work / development, project, and funds?
The scrutiny will be the same as for the third-party companies. And if you do in-house projects, they're going to come and see whether you're really developing in-house project or not, and whether the beneficiary is really working in that in-house project or not. If you're saying that an individual is going to work at the in-house project or your company, and if you have an established pattern saying that individual is going to work at the in-house project, but if you place them in the third-party client side later on, that can be used against you for the defrauding the immigration agencies. And that we have a simple sample example, recent decision by the Ninth Circuit in the Namrata Patnaik case, where the court found that they established a scheme of defrauding the government by stating that they have in-house project. Actually, there is no in-house project. They never use the individual services on the in-house project. They bring him in on that, and then they place it in the third-party clients and then file an amendments to the third-party companies. So you have to be careful on how you do that. So scrutiny will be the same, probably even a little bit higher if you say you have internal project and you file for them and you get to place them in the third-party client side.
Okay, if employee is working fully remote, still employer has to mention the employee will be working on a third-party location on a new form I-129.
Fully remote means whether the client location or the beneficiary home address or some independent location, depending upon that, and whichever the location.
Say not our office, but maybe from his home. What is that in that case?
As I said, we have to answer yes. We have to say beneficiary residence and then provide the beneficiary residence address over there, because that is what you're going to state in the LCA also.
Exactly. So the summary is except if it is petitioner's office, other than petitioner office, everything is a third party
location.
Period. Yes.
How is the process different compared to last year?
Everything
is different.
Everything is different right now. Everything now, we went back to prior to 2020. The requirements, the documentation, everything we have to prepare as if we are filing case in 2019 right now.
Okay. Is it mandatory to have a client letter? Is one question here.
As I said, it is not mandatory. It's one of the documents. I mean, you can substantiate that evidence of relationship with any number of documentation, either by client letters or by purchase orders or by MSAs or by some other documentation that can establish a contractual relationship between all the entities involved in the chain of relationship.
So what is the name of alternate wage survey?
There are several wage surveys are available, but the one we use in our office is h1b.
Okay.
Since this question came up again, let me ask you one thing. How about the level ones? Does it have the impact? 2-3 years ago, we used to be, hammered on the level ones. After that, again, we applied many and we got approval too. What is the situation on usage of the level one? Can you throw your thoughts?
As of today, we did not have any problem using level ones for the specialty occupation positions, just like software developers or a business intelligence analyst or computer architects, those positions. I'm talking about only IT positions. I'm not talking about any other position because our members most of them are IT consulting companies, that's why. And but in the eventual times, we saw in the previous Trump administration, they did started issuing an RFS for level 1 position. That's why all the employers started filing in level 2 based upon the requirements and everything. And USAS has been comfortable with level 2, so the practice has been going on from that time, since then, to file in level 2. So, it's possible that we might see more RFS coming in if you're filing in level 1s. But as I said, I'm not worried. We'll be able to respond to those RFS very successfully.
Okay, so can you provide the insight into the document that is being circulated in WhatsApp groups that staffing companies cannot do H1s while on OPT is valid? I mean, if it's a validity of 3 years, I think that is what he meant.
I think that's you can find so many things online and social media which is completely incorrect.
You can still file.
And a fraudulent information, mischievous information, rather fraudulent, I would say, mischievous information.
Okay. Mm, It says we haven't received any updates from USCIS regarding this year's lottery notification.
We will soon hear from them.
Also,
We'll soon hear from them.
some questions are repetitive, so I'm just going to skip them. Any changes to consular processing of h1b for employees selected in lottery?
No. Only changes, no changes. We have to show the requirements just like what it has been,
I see.
even in the past.
So we have transfer cases from India.
I'm sorry?
They have transfer cases from India, H1B transfer cases. How do we supply MSA as it will not have names on the beneficiary? Will it be successful?
Will it be successful? It depends upon what is the agreement is all about and what information is available. I think it's a better idea to reach out to us privately and so that we can discuss with them in detail what their facts are and then able to provide them proper advice, because this is a general forum. General forum this one, and it's very difficult to give a generic answer and a specific factual pattern.
Okay. Is the fee $215? Is a question. So
yeah, for the registration fee, H1B lottery registration, the fee from this area is $215 per beneficiary.
So in CRISP, no MCA, no filings for this cap, right?
I didn't understand.
No, if they don't have MSAs, that means we should not file. Is that the question?
I would strongly discourage them to file an H1B petition, especially if their business is providing supplying their employees to third-party companies for services.
Okay. What are the other documents needed to file H1 cap selection for a H4 dependent whose I-94 visa expiration in passport but file H4 extension along with spouse's H1 extension?
I didn't understand.
No, that is not quite clear. Move on. We have time limited.
Skip that. If there is no end client at the time of filing, what details should we provide in the place of client information?
As I told you, whatever your work location is, that's what we provide.
These are all pretty much repetitive. Do we need to give advertisement for applying H1B?
As I said, there's nothing wrong in posting an advertisement, but don't post that you're going to hire only H1B workers.
That's going to be a fire back at the discrimination.
So, don't say that you're going to hire OPT students, you're going to hire H1B workers, you're going to hire only US citizens or green card holders, especially when your company has a habit of hiring all types of people.
Don't expose yourself.
That's basically that's in violation of EU OC regulations, so they'll be in trouble.
Okay, so this is can we lower the prevailing wages by amending another new LCA within the same metro locations?
For the same position, no.
Okay.
Without a material change, we should not touch that. Material change has to be there. Yes.
Yes. Material change means it's a location as well as the job duties and responsibilities.
Correct.
And if it is the same position, same location, you cannot. And some clients comes and tells me that, well, the client reduced the rate. So it doesn't matter. It's your business problem. But if the position is the same, you cannot change the rate and by filing an amendment to H1B petition.
Okay. So if the H1B employee completed his project with the end client and returned to the employer's office, how long we have to find the new project, and for that employee, do we need to file an amendment because he returned to the office?
As mentioned, legal benching is still allowed.
Okay.
Okay? Legal benching has not been banned or stopped by the H1B moderation rule. Legal benching is always allowed. As long as employer paying the wages that are offered to the employee and employer lawfully states, and employer can establish that the employee is on the legal bench for the lawful reasons, that is in between the projects or anything like that, there is no problem for the employer. This is what we tell to the employers also during the site visit also. If somebody is on the bench and if he's on a lawful bench, let the officer know that he's on the lawful bench. He's in between the projects. There's nothing wrong with it.
I see.
There is a current update, Banu. USCA has just announced the new registration that is going to be from March 7th through Eastern March 24th to 2025, Eastern noon, 12 o'clock. So you guys can go ahead and read yourself the updated announcement from the USCA about the new shortly.
Thank you, sir. Because I good call. I didn't check my messages.
Just 5 minutes ago, just 5 minutes.
Yeah, because I'm in this call. I didn't check my messages, so I'm sorry for that.
No worries.
Appreciate
No, please. Thank you.
So we are past 4 minutes. So do you want me to continue reading, Banu? We have another 50 questions here, I think.
No, just go for another 5 minutes. Because, they can consult the Banu because we have the conflicting meetings with, he has appointments too. So maybe 5 minutes, Banu. Can you spare for us?
Yeah, I can spare 5 minutes, definitely.
Yeah. Let's go quick then on, please. For cap cases in a situation where the beneficiary is still outside US, can we expect a site visit?
Yes.
Okay, it's always there. As soon as the application goes in, yes. Can you please put full details on alternative wages service in a chat? I think they should contact you. I would like to understand why are we receiving audits when we are ensuring that amendments are filed for every consultant.
What kind of an audits you're talking about? I do not know.
We don't know. Okay.
Because there can be Department of Labor audit or ICE audit. What audit? Well, we don't know. We have to see what the issue is.
Okay.
Because audits are different from RFEs or site visits. So I'm a little bit confused with that word audit.
Audit, I see. How to show that employee will not be part of third-party organization hierarchy?
It's very easy. He's just your employee. He's not their employee.
Yeah.
Okay. And he's providing services on your behalf to that company, but not for that company, right? And that company is not controlling his job. You are the one who's controlling the job. As long as you can establish that, as well as you can show that you are responsible for checking his day-to-day activities and supervising him and getting an updates from him, I think it's very easy to establish. I'm not saying any complicated in that. Actually, it makes it easy for us, making sure that we explain that language properly to the USCIS and provide proper fact-to-fact pattern explanation over there. I think it will be very easy for us.
Okay.
And that is why it is an issue that needs to be litigated, and definitely it will end up in the court on this issue.
Good. Okay. And some are repetitive, so I'm skipping those. If the candidate is working from home, do we have to file amendment if they change client working at the same location?
If it's within the same metropolitan statistic, within the intended area of employment, if the location change is in a commutable distance of the intended area of employment was initially filed, and if the position remains the same or similar, then there is no material change as per the matter of CBO solution. So
what is the file radius on that?
There is no radius. Unfortunately, they took off the radius after 2011.
Okay, there's no radius. Do we need to provide project documentation while filing petition?
Answer is yes. If we have to work with the third-party client side.
Name of the wage library again that Banu uses.
Watson VAT.
Watson VAT?
Yes.
Okay. POs and SOWs are mostly with shorter duration with possible extension word added to it. Can we use file extension?
Yes. Absolutely, because you don't have to provide an itinerary or a day-to-day assignment. So yes.
Do we think that we need to slow down on filing H1s this year?
If you have a bona fide requirements, I would say no.
Okay.
I mean, it's your business.
That's,
So I don't see anything wrong with it as long as you're complying with the regulations.
and they have requirements.
Yes.
Can you throw light on new bill in March 2025 proposed?
there is no new bill. Basically, there was some data is being collected by the Congress Judicial Committee, Judicial Committee of House of Representatives and the Senate from various groups that are interested in the immigration policies of the USCIS. And recently, there is one Center for Immigration Studies. They provided their opinion and their advice and their suggestions what the immigration should be, especially with the business immigration with H1bs and everything. It is their proposal, but it's not going to be codified and it's not going to be a law. It is not a bill that has been introduced by the Congress in the House floor or anywhere else. Okay, so a lot of organizations will be given an opportunity to present their papers and present their opinion and present their reasons, stating why the immigration policy should be directed towards this way or towards that way and everything. And Itserve Alliance also can be a part of that. They can also request a standing before the Congress if they would like, should they like to do that.
I see. So we'll go.
There are so many, speculative acts are in progress. HIRE Act, Eagle Act, and h1b 119JU01. That's also going on. So many speculative things are going on because of the time constraint. Let's be specific to our targeted thing, and maybe one or two questions more, Kiran.
Okay, so are the short-term approvals coming back again? I mean, it's a big question, but
it's absolutely a possibility based upon the regulatory language in the h1b moderation rule.
Yes. And if anybody has it, please send it to the PAC. That's going to be a very good scenario for our litigation, please.
If they get any short-term approvals.
Yes.
Mm-hmm.
Okay. How many days is the bench period?
As long as it's a lawful bench. I mean, if it's a reasonable and a lawful bench.
We'll close this question. We'll close this with this question. I think Satish can answer this. Can we get recordings for this section by any chance?
Banu sir, no, it went up. Banu, why should I answer? Our expertise. Okay, done.
This meant for the audience who are joined this call because of times. And also, it's very important. I need to state this. I did not say this before. The discussion we had is meant for the general awareness purposes only. It does not constitute a legal advice nor create an attorney-client relationship. The opinions and the point of view expressed in this call purely of the speakers like I am, what my interpretation is about this particular h1b moderation rule, and what we think this rule will be implemented in everything. If you need a particular advice or a suggestion pertaining to your particular case or a fact pattern, I think you should reach us privately, or you can reach your attorneys if you have any of your attorneys to discuss with them privately, and they'll be very happy to assist you with. That's the reason why we advise, we encourage not to record this session because it's a very generic information over here.
Okay.
Absolutely, Banu. Well said. That is very true. This is, nothing to do with the organization. We always try to bring the experts and they try to express their own opinions to a particular situation. Every situation is very unique and we cannot compare with one with another one. If you have any situation, you need to consult your attorney. And, we have many attorneys and paneled with our organization as a sponsors. We always prefer them. They are very knowledgeable. Please work with them. And this is the opinions only. Please do not share the stuff over and do not take into assumptions. And as I said, we are seriously looking for those RFPs. Please send it over to the PAC department. Thank you, Banu. I truly appreciate your time and coming over and giving a very valuable, knowledgeable information, need of an hour, especially on the CAT registration and the modernization. Thank you. Thank you, Kiran.
Thank you, Satish. Thank you, Kiran. Thank you, Jay. Thank you, Naveen. I know he's on the mute right now, but I really thank you.
You have to step out, so you log down.
Yeah. Thank you all for giving this opportunity to me and to be part of this webinar. And I would like to congratulate one more time Itserve for keeping up, doing its job, and it's doing an amazing service to the industry. And keep rocking. Wish you all the best and have a wonderful day.
Thank you, sir. Bye, everyone.